So, one of the problems that Judge Grimm recognizes is that while companies must issue litigation holds, as we all know, it's disconcerting that they're subject to different standards. So many of you know that corporations who are in different or in many different districts can often be held to different standards. What we found in case law is in the Second and Fourth Circuit, there's case law that says documents that are in the possession of a non-party are considered to be under the party's control. But then in the Third, Fifth, and Ninth Circuit, preservation obligations don't extend to documents in possession of the non-party, which then requires a Rule 45 subpoena to get that information. So Judge Grimm does an excellent job of recognizing that this is an issue and that organizations, especially national organizations with multiple locations, are faced with this, which means they are stuck with having to comply with the most demanding standard. So that's something to think about. What jurisdiction does your organization operate? And have you thought about, at this point in time with the uncertainty in case law, are you abiding by the strictest standard? So Judge Grimm's opinion goes on to acknowledge that the courts are just like you and everyone attending this webinar, as us as corporations in this industry, are struggling specifically with knowing when the duty to preserve attaches, understanding the scope of the duty, and understanding what a breach looks like. So I want to look specifically at those three and talk briefly about them, and as we make sure we're doing okay on time. Okay. Specifically on the trigger of a duty, Judge Grimm looks at what is reasonably anticipated, and we all know the legal terminology of reasonable anticipation of litigation. And what he really details is the specific, predictable, and identifiable litigation. Great. What does that mean for us? It's case specific. Then he moves on to scope of duty and talks about policy suspension and implementation of a litigation hold. Well, great. That's fantastic. We all know that we have to suspend our policy. We all know that we need to implement a litigation hold. But what is the breadth and scope of that? Again, it's case dependent. Then breach of the duty. He considers reasonableness and does an excellent job pointing out that it should be proportional. Every judge should look at the amount in controversy, look at the burdens of preservation, and take all of those into consideration when determining what sanctions to impose for any breach of that duty. So Judge Grimm does provide us with a very workable analytical framework that will allow you as participants in the legal industry and corporate leadership, as well as other judges, to approach preservation issues in, I would say, Judge Grimm's words, with a greater level of comfort that your actions will not expose you to disproportionate costs or unpredictable outcomes of spoliation motions. And he goes on to write that sanctions should be determined by culpability of the spoliating party and prejudice to the other party. And he looks at these specifically. He breaks them down by the most egregious or the most harsh sanction, dismissal or default judgment, adverse inference being next, monetary I apologize, from the lightest to the most harsh, dismissal or default judgment, adverse inference, monetary sanctions, and contempt of court. The problem is there is, again, inconsistent case law. Some courts are requiring bad faith. Others require bad faith only for more severe sanctions, while others are saying we just need a mere showing of fault. So in this context, referring back to Victor Stanley 2, Judge Grimm granted the default judgment on the account of on the copyright infringement, but not on the others, since in his determination the spoliation did not result in what he called an irreparable or substantial prejudice. He also issued a permanent injunction on the copyright claim, which was not opposed by the defendant. And as I discussed earlier, he granted reasonable attorney's fees and costs, and since he believed the defendant would avoid payment, he held him in prison for civil contempt, or said he would, for up to 2 years, and again, that was reversed 10 days ago. The remaining claims remain to be tried by the court, and we may have a Victor Stanley 3 on our hands sometime soon. As many of you who are familiar with this area of law can recall, should recall, Qualcomm versus Broadcom case back in 2008 with the $8.5 million sanction, and that was a precedent-setting case at the time. Again, we look at Victor Stanley and Victor Stanley 2 now and recognize that not only is this a situation or a continuation of case law that is affecting not only organizations from a monetary standpoint, but potentially from a criminal standpoint. So you have to think about, as an attorney in an organization or as a corporation in general, and the attorneys that work within that corporation, how are you going to handle the preservation issues and the potential sanctions that follow now that you know that there is some potential subject liability in terms of criminal sanction or criminal outcome? So what are we going to take away from Victor Stanley 2? Legal holds and preservations, as we know, they're the de facto standard, but the courts don't agree on every nuance. And as you've seen through the past few slides, there's no one standard. Therefore, being subject to such uncertainty underscores why corporations, large and small, and I know that on this call we have a representative of every vertical, need a discovery risk mitigation protocol. It's important to understand how to manage at least the process to the best of your ability within your organization in light of the case law that is out there now and that, as we will see, will come out in the future. So with that, Brian, I'm going to turn it over to you.
All right, thank you, Julie. It was a very interesting discussion of the Victor Stanley case. I think there's a lot that we can take away from that as inside and outside counsel. How do we best prepare our clients to be able to respond to a litigation event? And as inside counsel, how do we protect our corporations to not have these kind of judgments against it? So having spent a great deal of my career working in a major corporation, the discovery planning aspect is very interesting to me. And how do we prepare our organizations to be able to respond in a consistent, timely, and a risk avoidance manner? So when I think of discovery planning, I'm thinking of risk mitigation and cost control. You've got to be able to have what we would call in the corporations as fit for purpose type of discovery. So what is the proper investment that you need to make as an organization to protect yourself? And of course, in great legal terms, the answer is it depends. And then consider who owns the project itself and the work product coming from that project. How do you embed your IT organization and your records management organization in your discovery processes? And then a fundamental question of which of these items do you have capability to do internally, and which of these do you need to go to vendor community to get support? So hopefully we'll be addressing these. Items that, of course, as inside counsel you need to consider is your overall litigation portfolio. Are you a Fortune 10 organization that deals with hundreds of cases a year just in the U.S. courts, or do you is it a strange year when you do get a litigation? Now, all these things will vary how much investment you want to make. As Julie was saying, what are the jurisdictions you work in? You need to have a discovery capabilities that are well aligned into those jurisdictions. And then an item that I've certainly counseled people to be aware of is what's the sophistication of the plaintiff's counsel? Do you normally run up against opposing counsel that is well versed in discovery, or is this a new area for them? As Julie was mentioning, we do have various verticals involved, and so look at your industry. Are you in a highly litigated or highly regulated concern? Or perhaps you have environmental issues that you need to be quite aware of. and then looking at that not only from the regulatory but then the non-government organizations that could potentially bring suit against you and stop operations. Again, on the organization itself, what's the size? What are the locations? Are you a one city, one state? Are you multinational with hundreds of satellite offices? What's the distribution of your ESI, your information stores? All keen in developing your overall plan. And then do you work in jurisdictions where you have privacy concerns, primarily in the European nations, with the big focus in Belgium on data privacy, and how do you attack discovery in those locations is very important, very critical to you, because we've certainly learned that you can't use those privacy laws to avoid U.S. discovery. So being a very left to right kind of person and everything's very linear, I always like to put things into steps. And the first thing I like to do in a project of this type is to create a vision. What does this future state look like? What are we going to be able to do? What is the story that we need to be able to articulate to senior management so that we can obtain the funding that we need to make this happen? Supporting CAS to that, of course, includes a project charter that we need to define very clearly. Here's where we're going to go, and here's the path we're going to take to get there. Here's the estimated spend over those months and years, and here's how we're going to phase in benefits to the organization. We don't want to do a project that doesn't have a good return on investment, and this project will have to compete with every other capital project in the organization. And so showing how this will benefit the company, how the board of directors will see positive results, is very important. Obviously, create a strategic plan to achieve that vision, and that will morph itself into your high-level project plan. What I've seen historically be successful is obviously using the EDRM, the Electronic Discovery Reference Model. A great bit of work out there in the public domain. Certainly encourage everybody to be very familiar with that. But let's work left to right as opposed to right to left. We've seen so many companies come to us and say, I just bought software piece X and want to plug it into the model in the middle and get immediate results. And they don't get the full return that they would expect on that product because they haven't done anything early on to start managing their information properly, or, as Julie was talking about, implement a good solid litigation hold. They're just going right in and looking at perhaps ECA or review technologies. So certainly encourage the left to right view, and you